Welcome back to South Florida Real Estate Update, and I'm delighted to welcome back Jim Cioffi, the Juris Doctor.
Nice to see you again, Curt.
Does not have his stethoscope today for various reasons, but he's still the heartbeat of the legal profession. Jim, we ask you here today to talk about homesteading in Florida. Most of us think of homesteading just as a tax break, but it has legal ramifications as well.
Yes, especially with regard to judgments. The property in Florida owned by a person whose primary residence, that lien of the judgment is not effective against that particular property. A judgment is 10 years from the time that it's actually recorded in the public records, and the homeowner could actually take steps to affirm that that is the homestead property and not subject to the lien of the creditors.
So if I'm deeply in debt and my creditors are coming after me and I'm living in my property that is homesteaded, they can't touch it.
That's correct.
And that's why O.J. Simpson moved to Florida.
That's right. He wanted to avoid all those judgments that were against him.
So he could be living in Florida in his home and be safe from having it touched to him.
Yes.
What other kind of legal protections does homesteading give you?
Well, in Florida, the Florida Constitution states that a spouse has to consent to the transfer or the mortgaging of a property. So very oftentimes, for instance, before you were married, you might have bought property in your individual name.
Right.
Then the marriage occurs and you decide you want to transfer the property, sell it. If that's your primary residence, your spouse has to actually sign the deed along with you. Even
though she's not on the deed itself, yes, she has to agree to the sale of the property.
Yes, because the original drafters of the Florida Constitution wanted to protect spouses so they weren't shocked when they came home one day and the spouse said, sorry, I sold your property and it's not ours any longer. And just to give them that right that they would have to consent to the sale of that property.
Well, let's say I'm married and I want to buy a home in my own name and get a mortgage on it. Does that same rule apply?
Yes, you can do that. And by the way, we call this the horrors of homestead because we've had so many horror stories result from that. An individual might say, okay, I'm going to buy a property in my own name and it's going to be my primary residence, not realizing that the spouse has to sign the mortgage, which they do. If you happen to be in a state where you're separated from your wife, you're getting a divorce, you might not realize that that disgruntled spouse has to also sign the mortgage at the time you close on that transaction, as long as you're married. So we recently had a closing that had to be postponed a month because the wife refused to sign the mortgage until the divorce became final. We could finally close. So that's one of those horrors of homestead stories.
So the legal concept here is that if I have a big debt before I'm married, say $10,000, after I get married, my spouse isn't automatically $5,000 in the hole.
That's correct.
But if I have a home and want to transfer it, she has to sign.
That's right. And we also had an interesting story, cultural differences. We're having a lot of Asians and others coming into the marketplace. Yeah. So we had a gentleman from Thailand obtaining a mortgage, and we told him, you'll have to have your spouse sign the mortgage. He said, my Thai wife or my American wife? Fortunately, we found out the American wife was the legal wife, the Thai wife, which is the ceremonial wife, so we only had the one wife sign the mortgage.
Any other stories about homesteading? You must run into a lot of messes.
Well, we do. There was a sale recently where the parties were getting divorced. It usually happens in situations where the parties are in a state of separation or divorce, when the party thinks they can just sell the property without the other spouse's consent. But this gentleman actually put the property on the market, not even thinking that his spouse would have to sign the documents. And they're going through the divorce, and now she's saying, no, I'm not going to sign that deed unless you give me a certain amount of money. So she's holding it over his head that he has to pay her some money before she'll sign the deed. So that's a consideration.
Let's not lose the concept here, though. The concept is you're protecting the roof over your head. Yes. If you're married, that one person just can't sell it and say, hey, I've taken the money, and then you're out.
Right.
Okay.
That's the basis.
Jim Cioffi, thank you for the, this is why you have a lawyer. Really, if you're in a real estate transaction, this is why you have a lawyer, because it may be simple to sign, but
you have to sort out the complexities.
You have to live with it. Okay, Jim Cioffi, the Juris Doctor.
Thank you, Curt.
Thanks for being here on South Florida Real Estate Update.
Pleasure.